Welcome. For Singapore RES students, understanding land law is key. Today we'll cover interests, estates, future interests, mortgages, and caveats. First, what does it mean to have an interest in land? It's not always straightforward ownership. We mainly see two types: legal interest. This is formal ownership recognized by law, usually meaning your name is on the title deed. Equitable interest. This is a beneficial interest, often held before legal ownership is transferred. A classic example is a buyer who has exercised the option to purchase. They don't legally own the property yet, but they have a binding interest. Property ownership includes a bundle of rights, e.g., possess, use, sell, lease, which are proprietary, meaning they are attached to the land and bind third parties. These rights are powerful but not unlimited, being subject to laws and regulations. Next, let's explore estates in land. This links to the concept of tenure. The idea that ultimately all land in Singapore belongs to the state. What individuals or companies hold is an on estate, which essentially defines the duration of their ownership or holding. Freehold estates offer the longest holding. Key types are estate in fee simple, highest ownership form, and estate in perpetuity SLG, similar, but with specific State Land Act conditions. 2. Leasehold estates. This grants ownership or holding rights for a fixed, definite period. Common lease lengths in Singapore are 99 years, or sometimes 999 years. Once the lease term expires, the property typically reverts to the state or the holder of the superior interest, like the freehold owner. 3. Life estate. This is created between private individuals where someone, the grantor, grants property rights to another person, the life tenant, only for the duration of the life tenant's life. Upon the life tenant's death, the property automatically reverts to the grantor or passes to a pre-designated remainder person. The life tenant has rights to use the property, but usually cannot sell or will it. Estates naturally lead us to future interests, rights to the property that will only activate later. Consider these. Reversionary interest, the owner's lessor's future right to regain property when a current lease or life estate ends. During the interim, they or a new owner usually collect rent. Remainder interest. This applies when, after a life estate or specific term ends, the property is designated to pass to a different third party, not back to the original grantor. That third party holds the remainder interest. Finally, let's demystify mortgages. A mortgage is fundamentally a security for a loan. The mortgagor, borrower, conveys their property title or interest to the mortgagee's lender as collateral. The borrower keeps possession, but the lender holds the title as security. We see legal mortgages, usually when the borrower already has legal title, and equitable mortgages, often when the borrower has an equitable interest, like buying a building under construction. Mortgagors have the right of redemption to reclaim title upon full loan repayment. If they default, the mortgagee's remedies include selling the property to recover the debt. Caveats lodged with SLA protect interests by providing public notice, e.g., buyer, bank claims, preventing improper dealings and encumbering titles. Failure to clear these encumbrances before sale completion creates a defective title, potentially voiding the sale for bona fide purchasers. And remember, mortgage loans come with different interest structures. Fixed rate, for a set period, or floating non-variable rate, often tied to benchmarks like SORA. In short, understanding interests, estates, future interests, mortgages, and caveats is fundamental for RES professionals. Keep learning and good luck.